The Supreme Court has more power than was envisaged by the Founding Fathers. Interview, question and answer format.
The US Supreme Court, powerful men and women who determine the constitutionality of laws? Surely this is not what the Founding Fathers intended. Shouldn't the Supreme Court only intervene if it is quite clear something is unconstitutional?
The Constitution was written in a very different time and age. The Constitution then is not fit for purpose now. Therefore, it is vital that the Supreme Court updates and helps the Constitution to evolve. The amendment process is so difficult that it is the role of the Supreme Court to allow this document to be relevant today. You say too much power. I say the perfect amount used in the right way. And no, the Supreme Court must intervene where there is disagreement, whether or not it's ambiguous. Otherwise, nothing will evolve.
But the court is unelected. How can your comments be deemed fair? Why should an unelected body have the right to determine whether something is within the principles of the Constitution or not? Surely we should leave that to our Congress, which is elected. The Founding Fathers never had this in mind.
An awful idea if I ever heard one. We cannot have a highly partisan legislature which looks at issues subjectively rather than objectively determine the constitutionality of our laws. That is a recipe for disaster. The Supreme Court, although unelected, is free from party politics and therefore is in a better position to determine whether or not a law is constitutional. Congress doesn't do that and will never do that. The Founding Fathers were not stupid. They knew that the country would evolve, and with it the Constitution would need to evolve. As Congress is so partisan, the likelihood of any amendments, even really important ones, passing is virtually impossible. So it is the role of the Supreme Court, through judicial review, to ensure that this happens. Remember, judicial review is implicit within the Constitution. Therefore, the Supreme Court is far from having more power than envisaged. They are applying the powers as set out in the Constitution.
But let's be honest. How many tangible checks on the court are there? It is virtually uncheckable and is able to do as it pleases.
Absolute rubbish. It can't do as it pleases. Firstly, the Supreme Court cannot act unless a case is brought before it. Secondly, as this is an appellate court, it can determine which cases it hears and which it doesn't. Otherwise, it would never be able to function appropriately. Thirdly, there are clear checks on its power. The Supreme Court doesn't determine its own formation or makeup. That is done via the President and via approval from the Senate. Therefore, the power of the Supreme Court arguably lies with those who appoint the justices. The executive is also able to pardon felons, perhaps at the behest of a Supreme Court decision. More importantly, Congress can actually force the issue if they want to, and initiate constitutional amendments which may influence the court. I'm not saying this is necessarily right, but it shows that your argument, suggesting that the court is all-powerful, is nonsense. And, to finish here, members of the court can be impeached by Congress if appropriate, and while this hasn't happened, it is still a clear indication that they certainly do not stray in outlook from the framers' original intentions.
But surely, if the court does override legislation as unconstitutional, then they have effectively taken a political position as a result of their action, furthering the evidence that they have become too powerful.
But this is also a nonsensical idea. Think about it. Whatever decision is taken by the court is potentially going to be political inadvertently. They don't go out to intentionally take one viewpoint over the other. Their first priority is to determine whether or not the Constitution has been violated. Nothing else. They are looking to uphold the Constitution in a modern setting. And given the Founding Fathers' understanding that the Constitution would need to be evolved, the Supreme Court's expansive interpretations are needed to keep the document relevant. They are not becoming all-powerful, they are upholding the Constitution as they see it. Some decisions can take months to agree or disagree, which shows that they are taking due time and care over the case.
But returning to the point of ambiguity, surely judicial review should be restrained if it is not clear as to whether or not an ambiguity can be proven.
Not at all. If anything, it should go the other way. The Supreme Court, whatever its makeup, be it liberal or conservative, have been more than willing to exploit such ambiguities to boost their agenda, therefore suggesting that it isn't all-powerful but merely exploiting the situation to their advantage. The Second Amendment is probably the most ambiguous, although some would say clear, amendment of the lot. Yet, in the case of McDonald versus Chicago in 2010, the Supreme Court was happy to interpret that the framers did indeed suggest that people had the right to a private armed defence. Also, if no ambiguous cases are ever decided, just how are people's rights going to be protected? Plessy versus Ferguson in 1896, Brown versus Board of Topeka in 1954, Overgeveld versus Hodges and the US versus Windsor in 2015. The Supreme Court needs to take on such cases in order to dispel the ambiguity once and for all, although I will concede that this doesn't always occur.
I must put it to you that they have become too powerful, perhaps even an imperial judiciary, one which the framers did not envisage, nor would welcome.
I reject that notion. Given our combined system of separate government and extreme partisanship in our current climate, without the Supreme Court, it could be argued that nothing would change. Legislators are averse to passing anything risky with such little bipartisanship, meaning that the basic rights of our very people will be perpetually denied, and this would not be good for our country. The Supreme Court is not too powerful and does not have more power than the framers envisaged. In fact, they are carrying out the evolution that the framers envisaged, implementing judicial review at the appropriate times and in the most professional way possible.